This is Barry Zalma on insurance. I'm an attorney who has retired from the practice of law and now spend my time as an insurance claims consultant and expert witness and author and producer of these videos. Today I'd like to speak about the equitable right an insurer has to salvage after a loss. In reaching conclusions about the equitable doctrine of salvage, I have looked for similar precedent on the similar equitable doctrine of subrogation that's covered in my book Zalma on Insurance Claims, Part 107, Second Edition. Equitable subrogation is stated as, quote, "He who through no fault of his own is caused to pay the debt of another is entitled to all the rights of the person whose debt he paid." The U.S. Supreme Court explained that it is a general rule that fraud or any gross misconduct on the part of the salvors in connection with property saved will work a forfeiture of the salvage, and that the evidence in a case before the Supreme Court with reference to the means employed to obtain a levy on the bonds in question and the sale thereof fully justified the court in the conclusion which it reached that no allowance ought to be made by way of equitable salvage for the monies advanced by him to obtain the return of the bonds to the company. This was Richardson versus Green, an 1890 decision of the U.S. Supreme Court. Similarly, to encourage seamen to render prompt service in future emergencies, Flagship Marine versus Belcher Towing dealt with equitable salvage, where the vessel was undeniably subject to a marine peril in that it was sinking prior to the services rendered by Port Royal to CJ Seafood. If the plaintiffs had no pre-existing duty to pump, haul, or repair the boat in trouble, the services were successful if it did not sink, and the plaintiffs are entitled to a salvage award since they saved the vessel. Equity establishes who can recover the proceeds of a sale of salvage after a fire. Equity, of course, is a doctrine of law that looks to what is fair to the parties involved. Equity does not deal with money judgments. To get a judgment from a court of equity, the plaintiff must first prove that no adequate or speedy remedy at law existed. If money damage will solve the problem, a court of equity will not interfere. And therefore, equitable salvage is defined as follows, quote, "The term salvage is sometimes used in cases in which property has been preserved from loss by the last of several advances by different persons. In such a case, the person making the last advance is frequently entitled to priority over the others on the ground that without his advance, the property would have been lost altogether. This right, which is sometimes called equitable salvage, and in the nature of a lien, is chiefly of importance with reference to payments made to prevent leases or policies of insurance from being forfeited, or to prevent mines and similar undertakings from being stopped or injured. Salvage loss is that kind of loss which is presumed would, but for certain services rendered and exertions made, have become a total loss. In the language of marine underwriters, this term means the difference between the amount of salvage after deducting the charges and the original value of the property insured. Quoting from Black's Law Dictionary, Revised 4th Edition, West Publishing Company in 1968. In the insurance context, salvage is an equitable right of the person who provides indemnity, the insurer. Now, there often raises a question of who gets the priority of rights to the salvage. One case involved a dispute among 3 groups of divers for the right to salvage silver from the cargo of a ship sunk and for the title to whatever silver is recovered. In resolving the problem, the court considered the common law of fines that treats property that is abandoned as returned to the state of nature, and thus is equivalent to property such as fish or ocean plants with no prior owner. The first person to reduce such property to possession, either actual or constructive, becomes its owner. A mere searcher has no rights in abandoned property, even if he succeeds in locating it. In particular, he has no right to exclude others from the attempt to recover it. Any competing searcher is entitled to enter the area where the abandoned property is and to seek to reduce it to his possession, as long as he or she acts without infringing on the concurrent rights of other searchers. The opinion in Eads v. Brazelton, a 1861 decision of the Arkansas Supreme Court, comprehensively set out the law of fines. It refers to and relies on a broad range of authorities for its conclusions, and its premise that a finding requires both intent and some form of possession remains accurate. In Eads, for example, had Brazelton placed his boat over the wreck with the means to raise its valuables, and had he persisted in efforts directed to raising the lead, his conduct would have constituted the only effectual guard over it, and thus judicially recognized a warning that other longing occupants would have been obliged to regard. In the Treasure Salvers litigation, Treasure Salvers, Inc., the group responsible for finding the treasure, was awarded Title II and an exclusive right to recover the entire cargo, which was scattered over a wide area. This is Treasure Salvers versus Unidentified Wrecked and Abandoned, a 1999 decision of the Fifth Circuit. The facts of that case, however, readily justified a ruling for Treasure Salvers under the law of fines. Treasure Salvers had not only the intent to acquire the entire cargo, but the proven capacity to do so. More important, Treasure Salvers had recovered a large part of the cargo and had placed the rest within its possession to the extent consistent with the nature of the cargo. And Treasure Salvers was engaged in systematic, unrelenting work to recover all the remaining cargo from the entire area over which it was scattered. Salvage law requires that to be a salvor, a party must have the intention and capacity to save the property involved, but the party need not have the intention to acquire it. In the salvage context, only the right to compensation for service, not the right to title, usually results. Possession is therefore more readily found under the law of fines. Success is essential to obtain a salvage reward. Even a would-be salvor who does not himself save the property involved will be paid for any service rendered that helps another salvor preserve the property. A salvor will frequently seek the right to salvage without interference, and the law will grant such an exclusive right if the first salvor's effort is ongoing and has a fair prospect of success. The grant of exclusive salvage rights is subject to equitable considerations. A contract salvor may be granted priority over a volunteer salvor. It is reasonable that the law should support the right of an owner to select a salvor for shipwrecked property rather than be subjected to a salvage award granted to a volunteer. A salvor may enforce an equitable claim as a first finder, especially if it obtains a salvage contract from the owner. In California versus Deep Sea Research, a 1998 decision of the U.S. Supreme Court, it reaffirmed the vitality of a series of cases dating back to the 19th century that held a government can assert sovereign immunity in an in rem admiralty proceeding only when it is in possession of the res, the property. Although these cases hold that a state lacking possession cannot assert sovereign immunity, courts have yet to provide a comprehensive definition of the possession requirement. In the case the Davis, an 1869 decision of the U.S. Supreme Court, the facts involved included a Reconstruction-era case decided under the analogous sovereign immunity of the United States. Earlier cases indicated a government in possession of the res, the property, was entitled to immunity from an in rem admiralty action. In a case, the Schooner Exchange versus McFadden, an 1812 decision of the U.S. Supreme Court, held that France was entitled to immunity regarding an in rem action against a French ship of war in the possession of French officers. The Davis, however, appears to be the first Supreme Court case holding that a government could not claim immunity because of a lack of possession. The Supreme Court held that while the court's decision in the Davis was issued over a century ago, its fundamental premise remains valid in rem admiralty actions. The Davis involved a ship where the United States transported a cargo of cotton aboard a private vessel that, after meeting with disaster at sea, was transported to a place of safety by a group of salvors. Upon the ship's arrival at port and before the cargo was delivered, the ship's salvors filed an in rem action in state court requesting a lien against the vessel and its cargo for salvage services rendered in saving the property. The United States intervened, claiming immunity based on its ownership of the cargo. The court in the Davis held an in rem action may be maintained against government property when the suit does not require that the property shall be taken out of the possession of the United States. The Supreme Court again interpreted the possession requirement in Compañía Española de Navegación Marítima versus Navemar, a 1938 decision of the Supreme Court. In the Navemar, a Spanish corporation brought an in rem admiralty suit against a Spanish steamship in federal court. The Spanish government claimed ownership of the vessel and challenged the court's jurisdiction on the basis of sovereign immunity. The court stated, to claim immunity, the Spanish government would need to demonstrate actual possession by some act of physical dominion or control. The court ultimately held Spain's claim of ownership, which arose from a decree of attachment rather than any physical presence could not qualify as possession for purposes of immunity. A state, therefore, must exert some element of physical control over the property to satisfy the possession requirement. Possession requires something more than mere ownership or legal control. Consider Aqualog, Inc. versus the State of Georgia, a 2010 decision of the 10th Circuit. This video was adapted from my book Zalma on Insurance Claims, Part 107, Second Edition, one part of a 10-volume treatise, Zalma on Insurance Claims, which is available from Amazon.com as both a Kindle book and as a paperback. If you found this video to be useful or interesting to your colleagues, please refer it on. It's free. And please subscribe to my Rumble channel, my YouTube channel, and my blog so that you can learn about future blog postings and future videos. Thank you for your attention.